The subject for the audio lecture today will be corporations. Corporations, just like sole proprietorships, partnerships, limited liability companies, are just another set of business entities that we are discussing. Corporation is treated as a legal person under all laws and actually has a lot of rights and privileges that we enjoy as individuals. Among those include certain access to courts, being treated as a legal entity or person in court, constitutional protections, including protections of the Fifth Amendment of due process, equal protection of the laws, First Amendment privilege for right of freedom of speech, etc. Fourth Amendment, which we're going to discuss in just a minute, also applies to corporations with a couple of exceptions that do not apply for individuals. Corporations do not enjoy the Fifth Amendment right to remain silent or the privilege against self-incrimination that individuals enjoy. Corporations, like limited liability companies and like limited partnerships, have limited liability protection for their owners. The owners of corporations are known as the shareholders of the corporations. The owners of limited liability companies are known as the members, and the owners of limited partnerships are the partners, the limited partners, and general partners. All are considered to be owners of those particular kind of entities. It will be important for purposes of the exam that you can identify the owners of each of these various sorts of entities. For taxation purposes, corporations are unique in that they actually can be taxed in two different ways. The normal, standard, regular corporation, or what is known as a C corporation, is a corporation that has made no special tax elections and is treated as an entity for purposes of the Internal Revenue Code, which means that the Internal Revenue Code taxes it under special tax tables that apply to corporations and corporations only. Unlike a limited liability company and unlike a partnership, a C corporation is taxed. If I asked you the question, which of the following entities are taxed, the only correct answer so far of the answers of the possibilities I've given you is a C corporation. Limited liability companies are not taxed. Remember, it is a flow-through or pass-through tax entity. Partnerships are also a flow-through or pass-through tax entity. A C corporation is not a flow-through or pass-through tax entity. It is actually an entity that pays tax on its earned income. And that's important. And we're going to talk about an exception or another way that corporations can be taxed in just a minute. But first we're going to discuss the regular C corporation, or continue discussing the regular C corporation, and see how it actually applies in something that you may have heard of before called the concept of double taxation. Let's think about this for a minute. Let's say that we have an entity that's a limited liability company and it has two owners or two members, Abel and Baker. Abel owns 50% of the LLC and Baker owns 50% of the LLC. The LLC earns $100,000 of net income during the year. because the LLC is a pass-through or a flow-through tax entity, it pays zero income tax. However, Abel and Baker each have to recognize $50,000 worth of income from their ownership interest in the LLC, and they have to pay tax on that at their individual income tax level. So if the LLC distributes the $50,000 to them, they've got $50,000. Let's say that they are in a 30% tax bracket, just to make the math easy. Then each of them will pay $15,000 in income tax on the $50,000 they received, and as a result they would end up with a net of $35,000 in their pocket. Now let's change this and see how a corporation, or I should say a C corporation, which is the only one we've discussed so far, let's see how a C corporation may differ. Well, the corporation has $100,000 of income in our hypothetical, just like the LLC has. Because it has $100,000 of income, of net income, and because the C corporation is a taxable entity, first one we've had so far, then it has to pay tax on that income. Now let's just assume that it has a 20% tax rate for our purposes for this hypothetical. It doesn't, but it's for purposes of this hypothetical, and to make the math easy, we're just going to pretend like the corporate tax rate is 20%. That means that the corporation will pay $20,000 of income tax on the $100,000 of income that it earned, and it has a resulting $80,000 left over. Now the corporation distributes $40,000 to Abel, a 50% shareholder, and to Baker, a 50% shareholder. Each of them receives $40,000 net after the corporation has paid taxes. Well, that's called a dividend, and dividends are taxable to individuals at their individual income tax rate. Again, to make the math easy, we'll assume that it's the same 30% tax bracket that they were in when they were part of the LLC. As a result, they'll have $40,000 each of income that they're going to pay 30% taxes on, or $12,000, leaving each of them with a net of $28,000 in their pocket. Now, what happened here? Well, here's what happened. When they were with the LLC, they retained more of the income in their pocket because only one level of tax was being employed, and that is the individual entity tax level. They were being taxed at their individual tax rate only because the LLC does not pay income tax at its at the taxable entity level. On the other hand, what we have here is that the corporation is an entity. That's one level of tax, and then there is a second level of tax when the individuals receive the dividends distributed to them from the corporation, and that's a second level of tax, or a double tax, and that's what is known as double taxation. Now, how could we prevent that? Well, we could prevent that in a number of different ways, and this isn't a tax class, so I'm not going to get very detailed with you, but let's pretend that Abel and Baker, as the only shareholders in the company, are also two key employees of the company. Can you think of any other way that they could receive money from the corporation and yet not have it be as a dividend? Well, if Abel and Baker were employees of the corporation, they could receive a bonus or salary equal to the amount that the corporation earned. So if the corporation had net income of $100,000, as they did in this hypothetical, and they bonused $50,000 to Abel and $50,000 to Baker, yes, they still have to pay tax at their individual tax level, whatever that rate is, and in our example it was 30%, but salary, wages, or bonuses are tax deductible by a corporation. So instead of having $100,000 of net income, if they issued it all out as a bonus or a salary increase, then they would actually have zero taxable income and pay zero taxes. So basically this gets us close to where the LLC is. It's not perfect because we also have some payroll taxes, SSI, FICA, Social Security taxes, withholding taxes that are associated with salaries or bonuses. But it gets close. That is a way of addressing it. We've discussed this before when we talked about the material on agency, the concept of respondeat superior. And the concept of respondeat superior means that the principal, or in this case the corporation, is responsible for the actions of its agents or employees or officers committed within the course and scope of their employment. So, example, if you have a corporation whose employee is charged with the duty of making a hand delivery from its office to one of its clients' offices, and it hits someone in the car while it's en route, then the corporation is responsible for the actions of that agent committed within the course and scope of the employment. Corporate officers can also be held sometimes personally liable for corporate crimes. And we have a very good example of that right here in Birmingham, Alabama. And I bet if I pause for about half a second, you'll think of exactly what this is. And that is Health South Corporation. As you may recall, Health South Corporation was charged with a number of crimes that generally related to falsifying financial statements and financial information. It had the effect of artificially inflating the stock price, which defrauded shareholders purchasing the stock at a price that was higher than it should have been. Well, there were a number of different officers that actually went to jail for those corporate crimes, for the false and fraudulent financial statements. It's a very, very interesting story of what occurred. There were a number of other unfortunate type of events like this with other companies such as Enron, but again, we have a very good example right here with the Health South Corporation. Corporation itself, it's kind of hard to put a corporation in jail, but it's not hard to find the corporation, and in some circumstances, corporations may be fined for the actions of their agents and employees as well. Very easy definitions here. A domestic corporation is a corporation that incorporates in its home state. So if you are beginning a business here in Birmingham, Alabama, you incorporate in Alabama, you are a domestic corporation. If you decide for other reasons you want to incorporate under Delaware, a lot of companies do. Delaware has very favorable corporate laws. and then you qualify to do business in the state of Alabama, you will be known as a foreign corporation. And then an alien corporation, very simply, is one that originates in another country. Close corporation is one that that involves a small number of owners. And I don't have a specific number, but typically the ones that I'm involved with are all fall under this category of close corporations. And there are some very, very big companies. It doesn't mean that it's small necessarily, although most of them are. Doesn't have to be. The definition doesn't relate to the size of the corporation. It relates to the number of people who are owning it. Hobby Lobby is a close corporation involved in as a private company that whose ownership is basically concentrated in one family. Okay, let's discuss the tax aspects of corporations that are not C corporations. When we discussed the concept of double taxation a few minutes ago, we discussed the fact that that was the normal, regular, or C corporation status. And I mentioned then that there was another one, and we are now at that point, and that is the S corporation or subchapter S corporation. S corporation and C corporation basically mean that the corporations are taxed under a particular subchapter of the Internal Revenue Code. Guess what subchapter of the Internal Revenue Code an S corporation is taxed under? If you guessed subchapter S, you would be correct. Guess what subchapter a C corporation is taxed under the Internal Revenue Code? If you guess subchapter C, you would also be correct. Now, S corporation status occurs because a corporation, and it's exactly the same as a C corporation, they're both corporations, has made a special tax election. That's all it is, a tax election. It has nothing to do with the validity of the corporation, whether the corporation provides the same liability protection, or anything of that nature. In fact, it has only one difference at all, and that is a tax election has been made. Now, having said that, most of the time, subchapter S corporations look different, taste different, smell different. They walk and talk different than a C corporation. Why? Because only certain types of corporations can qualify for that special tax election. And if you look on slide number 8, you can see some of the examples. You've got to be, in order to be a subchapter S corporation, you can only have certain types of shareholders. You can't be an alien corporation. You can't be a member of an affiliated group of corporations. You have to have 100 or fewer shareholders. Walmart Corporation could not be a subchapter S corporation because they have many millions of corporations. Subchapter S corporation can have only one class of stock, although voting right differences will not make it a separate class of stock. Also, I should mention on the 100 or fewer shareholders, there's a special provision that says that a husband and wife, when both own stock, shall be treated as only one shareholder. So actually, you could have as many as 200 if you had 100 husbands and wives that owned shares of stock in the same corporation. How is a corporation formed? Well, we discussed this a little bit when we were in the small business organization chapter. Basically, in most states, and even in Alabama still, although we are phasing that out, you file articles of incorporation with the judge of probate in the county in which you'd like to incorporate the business. Alabama is a little bit different now in that we have a special Business Entities Act that was enacted 2 years ago, and that special Business Entities Act now provides for a unified certificate of formation to be filed with the judge of probate in the county of the intended formation. And that certificate of formation is similar whether it is a corporation or a limited liability company. It really doesn't matter either way. Both of them use what's called a certificate of formation now. And that's a public record. If I incorporated a business a few weeks ago, and if you wanted to see the certificate of formation and certain public information about that new corporation, you could trot down to probate court and retrieve a copy of the records, or even better, you can today get on the Alabama Secretary of State website and actually retrieve those records yourself. I had a lawsuit about a month ago in which it was relevant, the ownership interest and the registered agent for a particular corporation, and actually obtained a certified copy of the original articles of incorporation of this corporation without leaving my computer. Could actually do it all online by paying a fee. Corporations are governed by individual state laws, and whatever the state law says is what you've got to follow. As I said, in most states you file articles of incorporation, but not all. In Alabama, again, you now file something called certificate of formation. You can still, and I understand the clerks of court are still taking them, you can still file articles of incorporation with the judge of probate, and that be fine. Corporations can exist for a specific period of time. Most of them are perpetual, which means they go on and on and on until they are dissolved in one form or another. How do you incorporate? I'm going to go over this fairly quickly. It's not really that complicated, but generally speaking, you reserve a corporate name with the Secretary of State. Again, you can do this online now. You pay a fee. I think it's about $28 to file the fee. You file once you obtain that name reservation certificate, you file it along with articles of incorporation or a certificate of formation with the judge of probate. You pay a fee to the judge of probate. It's about $60, give or take. And you pay a fee to the Secretary of State, and that one's $100. The articles of incorporation or the certificate of formation must contain a registered office and a registered agent. And that's the person who is charged with the responsibility of receiving legal notices, like if the corporation gets sued. If the corporation gets sued, they got to know where to send the lawsuit to the corporation, and this tells you where. Also list the incorporators as well. Incorporator really is an administrative kind of task, and they don't have to have any affiliation with the corporation at all. The one that I did about a month ago, I was the incorporator. I don't have any ownership interest in that corporation at all. Nothing at all to do with it other than I was the lawyer who incorporated it. In fact, I typically in the past, when I had a full-time secretary, would have my secretary be the incorporator of the particular entity. What happens if the incorporation doesn't quite meet the requirements, the statutory requirements? Well, basically, you've got a couple of different exceptions here or specific provisions. One is if you got really close, substantially complied with the statutory requirements. They call that a de jure or of law incorporation, and the corporation cannot be attacked by anyone. It's basically good enough. You get substantial enough. Second one is de facto, and if that's one where the promoters made a good faith effort, they tried, but they really didn't meet the statutory requirements and they really weren't substantially close, it's still going to be considered a corporation for most purposes. However, the status could be attacked by the state itself, and the state could seek to dissolve it. Typically won't, but could. And the final improper incorporation status is really one that could apply to either one, and it basically says, look, if you look like a corporation, you act like a corporation, you walk and talk like a corporation, you are a corporation. We're not going to let you avoid liability, corporate liability, by claiming that you didn't follow the right particular guidelines and formalities. And that's by estoppel. Ultra vires doctrine is a special doctrine that says that if you have certain powers that are not included in the Articles of Incorporation, then that's going to be considered beyond the scope of the corporation, and you could subject the corporation to lawsuits and a lot of liability. Now, how do you avoid this? Well, I'll give you a good example. Most lawyers I know do the same exact thing I do. We all kind of plagiarize each other, or plagiarize kind of from the same sources. And we kind of have the same sort of general practice, and that is this. If I'm incorporating, let's say, a paint and body shop, I will put as the purpose of that corporation to engage in the business of painting automobiles and other vehicles of different types, to repair automobiles, to provide body work, body frame, etc., to engage in any and all dealings with automobiles and other vehicles, including trucks and other motorized or non-motorized vehicles. And power number 2, any and all other powers permitted under the Alabama Business Corporation Act. You see what we just did? Basically, power number 2 gave them any power to engage in any legal business at all. Let's say that you had a paint and body shop and it decided it wanted to go into the business of buying and selling cars. Well, you're covered now. Let's say they wanted to set up that lemonade stand that we started in the Small Business Organizations chapter. If they wanted to do that, put it outside their business, they're covered by that second power. So I like to be as specific as I can with respect to exactly what they're going to be doing. It's not absolutely necessary to do that, but I just feel better about doing it that way. And then of course add a second very broad purpose to avoid being sued. And here's what happens if you have ultra vires actions. Lots of bad stuff. Damages, lawsuits. Shareholders can sue, called shareholder derivative lawsuits. The state can get involved and try to dissolve the corporation. The corporation can sue its officers and directors. It's a mess. Let's talk about a legal concept that is contrary to the purpose of forming a corporation or a limited partnership or limited liability company. One of the reasons that we form these LLCs or LPs or corporations, one of the very strong reasons is because we want to provide liability protection for the owners. We talked about it in the lemonade stand. Let's incorporate that lemonade stand. Let's call it the Abel Baker lemonade stand. We got Abel and Baker that are the owners, known as the shareholders in a corporation. They file a certificate of formation after they've obtained a name reservation certificate from the Secretary of State for Abel Baker Incorporated, Abel Baker Lemonade Incorporated. They file a certificate of formation, they pay all their fees, and they are now a corporation. They may decide to make a special tax election and be treated and be taxed as a subchapter S corporation, although they don't have to. They could elect to be taxed at the corporate level. Usually small companies don't, but they could. We've done all that. Well, now the reason for doing it is so that Abel can put in his $5,000 and Baker can put in his $5,000, and they've got $10,000 invested in the enterprise, in Abel Baker Lemonade Incorporated, and that's all they've got at risk, the $10,000. They sell some bad lemonade to somebody, they keel over and die, and their estate sues Abel Baker Lemonade Incorporated. They can't also sue Abel individually and Baker individually. So Abel's personal assets, his personal bank account, his car, his house, all of his personal assets are safe and secure. Same for Baker. Well, what happens if we decide that the owners aren't really doing what they should do? And by this I mean they're not treating the corporation as a real corporation. And there are some reasons where it just doesn't seem fair to allow them to escape liability. Not in the example I gave, because I didn't give you enough facts to make it appear to be unfair. But let's say that, for whatever reason, we tricked people into thinking they were dealing with an individual. It turned out they're really dealing with a corporation. The bottom one, the third one that you see here on slide number 16, probably the most important, statutory formalities not followed. You commingle bank accounts. You have a corporate, let's take it away from Abel and Baker. Let's just call it Abel's Lemonade Stand Incorporated. We've got one owner, only one owner, one person. Abel's got an individual bank account. Abel Baker Lemonade, or Abel Lemonade Incorporated, also has a corporate bank account. But he takes that bank account money and he puts it in his individual account. He pays his house note with his corporate account. He puts personal funds in the corporation and puts corporate funds in his individual, and basically commingles them to the point where there's really no identification of the corporation at all. Now let's assume that he doesn't file any of his proper paperwork with the state. He doesn't file any of his returns, his personal business privilege return, doesn't get his licenses that he's supposed to do. He doesn't hold a board of directors meeting with the board of directors. He doesn't hold shareholder meetings. He doesn't file anything. Basically, he just ignores corporate formalities. Well, a court in a case like that is going to look at it and they're going to say, well, wait a minute. You're not treating this as a real live corporation. And if you're not treating it as a real live corporation, why should we treat it as a real live corporation? And the answer is, we don't. We will allow someone harmed by the corporation in a case like this to pierce the corporate veil, to go right through the corporation down to the individuals themselves. And that's a disaster if you are that owner of the corporation. Basically, the primary reason, or one of the primary reasons for you to have incorporated is limited liability protection, and now you have no liability protection because they have pierced right through that. That middle factor, corporations set up never to make a profit, insolvent, undercapitalized. There was a pretty famous case involved in New York in which there was a taxi cab company. And the taxi cab company had about 50 different taxi cabs. And rather than purchasing enough insurance, which is something that I highly recommend, as I mentioned before, if you're going to engage in business, get good, strong liability insurance to protect yourself. But rather than doing that, they purchased the absolute minimum, and what they did is they separately incorporated each taxi cab. So let's say that you've got 50 different taxi cabs, and let's say they're each worth, $10,000 to make the math easy. Well, if you've got 50 different taxi cabs, and they're each worth $10,000 each, you've got about $500,000 of assets in taxi cabs alone. You have one of your taxi cabs runs over someone, and you're carrying $10,000 worth of insurance, and they sue you for $500,000. If you've got $500,000 of assets in the company, well, they can put the company under by taking all of the assets of the company. So what this smart, I'm using that term loosely, what this smart taxi cab company decided to do is this. They made Taxi Cab Corporation A, Taxi Cab Corporation B, Taxi Cab Corporation C, all the way down through double Z, and 50 or 52 different corporations for the 50 or 52 different taxi cabs they owned. That way, if Taxi Cab A is involved in an automobile accident and they get sued, the worst that can happen is they get the $10,000 minimum insurance and maybe a $10,000 automobile. And the real owner of all of the shares of all the different taxi cabs, they're not hurt too badly, are they? They just lost one taxi cab. They still have 49 that are left. Well, it was a great try, and it was pretty creative. It was pretty smart, but not smart enough. And the court there, when they got sued, held the corporation was severely undercapitalized. It did not have enough assets to engage in the business, the 50 or 52 taxi cab kind of business in which they were really engaged. And that kind of made sense. Alter ego, I basically have combined alter ego with piercing the corporate veil because the concepts are very, very similar, and that is losing the identity, and when you do that, the corporation, the courts say, if you're losing the identity, so can we. Loans to the corporation. A lot of people think that's not appropriate or not proper when in fact it is. It's perfectly fine. In fact, I represented a company. It's a locally owned company here in Birmingham, Alabama, a very nice, very big but closely held company in Birmingham. And they were audited by the IRS and had a very large tax bill, about $180,000 of taxes that they said they owed. I filed a petition in tax court representing this company, and the vast majority of the taxes came because the individual family members of this family-owned business were taking their own personal assets and personal monies and contributing it to the corporation, because the corporation, the business, just isn't doing well. Not doing well at all, still isn't doing well. And so it needed money. It needed to borrow money. And it couldn't just borrow the money from the banks that it needed to borrow, and the individual family members had plenty of assets that they could use to kind of prop up the business. So they put money into the business. Well, the IRS came in and they said, look, you're getting all this income every year, you know, $60, $70, $90, $100,000 of income that's coming into the business, and you don't have any paperwork on this. We're going to assume that it's all income. So what they were doing is very carefully scrutinizing the transactions. Fortunately, I was successful in convincing an appeals officer before we even went to trial that the monies that the individual owners had put in was, in fact, loans. They were loans to the corporation, and as such did not represent income. And again, this isn't a tax class, but think about it. If you're in the business of selling widgets, you sell widgets and you get the money for the widgets, that's income. But if you go to the bank and you borrow $100,000 to help build a widget factory, when you get that $100,000 from the bank, that's a loan. You owe that money back. That's not income. You shouldn't have to pay taxes on it, and you don't have to pay taxes on it. Well, instead of borrowing the money from the bank for your widget factory, if you borrowed it from shareholders, family members, others involved in the corporation, it's still a loan. It's not income, and it's not. Moral of the story is you're going to be carefully scrutinized, though, when those kind of things occur. One of the things that I'm going to hold you responsible for knowing is the ownership of each of the entities, as we've discussed before, but also who governs the various entities, who manages them, who directs them, whatever. For corporations, you're going to have to know basically 3 different types of directors, shareholders, and officers. The shareholders, we'll start with them, the ones that we've discussed before, and they are the owners of the corporation. They are the big dogs. The shareholders are not, however, involved in a day-to-day kind of basis. All their interest is in owning the corporation and in electing the board of director members. Board of director members are elected by the shareholders. You have to know that. What do board of directors do? Well, directors are responsible for implementing the overall policy of the corporation, the management of the corporation, establishing the guidelines, and also for appointing or electing or hiring the officers of the corporation. They're going to be the ones responsible for hiring the president, vice president, secretary, treasurer of the corporation. What are the officers responsible for? Well, the officers are responsible for the day-to-day normal management of the ongoing business. And again, you are going to be responsible for having to know all of that as well. I bet you'll be glad to know my database has been my antivirus has been updated. Board of directors. Board of directors meetings must be held at least annually and can be done more frequently than annually. They can be done with sufficient notice under a special meeting. Here's a new term you're going to have to know. It's called a quorum, Quorum, and a quorum is the minimum number of directors necessary to conduct official corporate business. It's not always a majority. For our purpose, for testing purposes, I'm going to call it a majority. It's good enough. That's most of the time it is a majority. Not always, but most of the time that's the case. Now let's see how this works. You're going to have to know how this works, so please pay close attention. Take good notes here. Let's pretend that a corporation has 9 board of directors members. 9 directors on its board. How many would a quorum be? A quorum would be a majority or 5. So that means you must have at least 5 directors present at a meeting in order to validly conduct official corporate business. Now, how many would be required normally to pass some official vote? Let's say that we want to appoint a new vice president of marketing as an officer, and we have the bare minimum number of directors there to conduct official business, the quorum, which is 5. How many of those 5 would have to vote in favor of this new person occupying this new position? If you said a majority of the people, of the board of director members that were there present at the meeting, you would be correct. So the answer there would be 3. So let's think about that for a minute. 3 board of director members are all that's required in order to officially conduct business. In order to officially pass some corporate business, if they had a bare minimum number there at the meeting. For purposes of the test, I very well may ask you a question like, Acme Corporation has 32 board of director members. How many would be the least number possible under any circumstance to vote in favor of a corporate action for it to be valid and legal? And the answer there, I'm going to run the math through my head. A majority of 32 would be 17, not 16, but 17. 16 is not a majority, it's exactly half, and you need a majority. So it'd be 17 would be a quorum, and then a majority of 17 would be 9. So 9 directors out of 32 would be the least number ever possible to vote in favor of a corporate action for it to be legal under very specific circumstances. You can use a calculator, perfectly fine for purposes of the test, but please pay close attention, and if you have any questions about this, ask me about it in class in our next class meeting. There are a number of different committees that the board of directors can have. Slide 20 gives you an example of some of them. One thing that I should mention is that, especially with closely held companies or close corporations, the same people can occupy more than one position. You've got Abel and Baker Lemonade Stand Incorporated. Abel and Baker are the shareholders. Who do you think are going to be on the board of directors? Abel will be, and Baker will be. So there'll be shareholders and board of directors. Who do you think is going to be the officers? Guess what? Abel will probably be the president, and Baker will probably be the vice president, or vice versa. So it's not uncommon at all for the same people to occupy different positions. But it is still important for purposes of the test and in real life for you to know the difference between who sets the overall policy of the corporation, directors, who elects the board of directors, shareholders, who appoints or hires the officers, the board of directors, who is responsible for the day-to-day management of the company, the officers. All of these things are very, very important for you to know and be aware of. All of them have certain duties, responsibilities, and fiduciary and loyalty obligations to the corporation. And that brings us to a good stopping point. We will pick up with slide 23 and obligations for directors. We're going to move in to do some discussion of shareholder derivative lawsuits, etc., in our next class period. Thank you, and hope this didn't put you to sleep.